As praias de águas cristalinas e piscinas naturais formadas entre os recifes fazem de Porto de Galinhas um dos mais belos destinos do Nordeste brasileiro. Este cenário paradisíaco vai receber em agosto o maior evento de propriedade intelectual e direito digital da América Latina. Porto de Galinhas será a sede do 44º Congresso Internacional da ABPI, tanto pela infraestrutura e beleza, quanto pela sua proximidade com a capital de Pernambuco. Está a 30 minutos de Recife e do Aeroporto Internacional dos Guararapes. Terra de um povo alegre e hospitaleiro, onde passado e futuro se encontram no misto de história, cultura e inovação, Recife tem a 4ª maior região metropolitana do país e é um hub para o desenvolvimento econômico de outros estados do Nordeste. Além disso, abriga o Porto Digital, um dos mais importantes polos tecnológicos do mundo, onde estão mais de 350 empresas e 20 mil profissionais trabalhando com inovação e tecnologia de ponta. Um cenário que coloca a capital pernambucana entre as 6 cidades líderes mundiais da indústria de TI, segundo o portal internacional Rest of World. E é de olho em todo este potencial que, pela primeira vez, a ABPI decidiu levar o evento para a região. Nos dias 12 e 13 de agosto de 2024, os maiores especialistas e profissionais de IPI do mundo todo estarão em Porto de Galinhas para debater os principais temas de propriedade intelectual e direito digital. E também, é claro, para muito networking.
Não perca a chance de fazer parte desse evento. Junte-se a nós no 44º Congresso Internacional da Propriedade Intelectual da ABPI. Estamos ansiosos para te receber lá.
Bom dia a todos, a todas. Eu não sei se a ferramenta de tradução simultânea já está funcionando. Cornelius, is it working? Ok. Então eu vou falar aqui em português. Primeiro, dizer que é uma honra para a Comissão de Estudos em Direito Internacional da Propriedade Intelectual da ABPI estar organizando esse painel. A gente tem aqui hoje com a gente o Cornelius Kleiner. Cornelius é um advogado alemão que atua nas áreas de propriedade intelectual, tecnologia e proteção de dados. Ele é doutor em Direito pela Universidade de Freiburg, na Alemanha. Ele também atuou de 2015 a 2021 como assistente de pesquisa no Centro para Estudos Jurídicos Aplicados no Institute for Information and Economic Law, do Instituto de Tecnologia Karlsruhe. E o Cornelius, que tem ampla experiência, né, nessa área, ele vai falar com a gente hoje sobre o Digital Markets Act, ou o DMA, né, que é uma lei que faz parte do arcabouço normativo da União Europeia para a regulamentação das plataformas digitais. Bom, recentemente, né, a União Europeia aprovou 2 leis, o Digital Services Act, que é o DSA, e o Digital Markets Act, que é o DMA. E juntas, essas leis consolidam os esforços de regulamentação do mercado digital, das plataformas digitais no âmbito da União Europeia. Certamente, né, como ocorre com diversas matérias, essas normas vão inspirar a criação de outras leis mundo afora, inclusive no Brasil, né? A gente viu isso acontecer há pouco tempo atrás, por exemplo, com a LGPD, a Lei Brasileira de Proteção de Dados, que foi inspirada, né, no GDPR, né, que é a lei europeia sobre o assunto. Bom, o DMA ele estabelece regras voltadas a plataformas digitais que têm grande presença no mercado, que são as chamadas gatekeepers, né? Essas empresas que foram designadas como gatekeepers são empresas que atuam com grande presença no mercado de plataforma digital. E o DMA ele tem como objetivo estimular a concorrência nos mercados digitais e facilitar a entrada de novos competidores impondo regras para evitar que essas grandes empresas, né, os gatekeepers, abusem das suas posições. Mas o DMA tem recebido algumas críticas de pessoas que dizem que, ao facilitar o ingresso de competidores no mercado, essa nova legislação pode colocar em risco a segurança dos dispositivos dos usuários, a segurança dos softwares que ficam mais vulneráveis a ataques cibernéticos e acesso indevido a informações confidenciais. Enfim, o DMA ele passou a ser aplicável na Europa há poucos meses e vai ser importante a gente observar a sua implementação. Nesse contexto, o Cornelius vai poder trazer hoje para a gente uma visão geral do DMA e dos principais desafios envolvidos. Eu espero que nós tenhamos um encontro muito produtivo nessa manhã. Eu vou passar a palavra ao Cornelius. Eu peço que anotem eventuais perguntas que possam ter sobre o tema. Ao final da apresentação, nós temos um espaço para perguntas e respostas. A apresentação vai ser em inglês, mas nós temos uma ferramenta de tradução simultânea para o português. Tem um botão aqui na barra de ferramentas, que é o símbolo de um globo, tá? Em que é possível escolher o idioma de preferência. Tá? Quem puder fazer as perguntas em inglês, pode fazer direto em inglês. Se preferirem, podem mandar em português também, que a gente traduz. Muito obrigado. Cornelius, the stage is with you.
So, thank you very much for the introduction. It's very nice to be here. I was asked to give an overview of the EU Digital Markets Act, or Regulation EU 2022-1925, as it is called in Europe. So, can you see one screen or two screens?
No, one screen only.
Perfect.
Thank you.
Okay. Digital services and online platforms play an increasing role in the economy today. I mean, we are having this meeting on Zoom at the moment. Zoom is one of the companies that really spurred during the pandemic in Germany and Europe, and I believe it is probably the same in Brazil. However, these services have characteristics that can favor a market imbalance even when they are not purposefully designed to do so. They rely on extreme scale economics. So there are high ramp-up costs to create a platform. But then the adoption of every following user does not necessitate large investments again. So it's hard to start and then easy to gain market share if there are no competitors yet. There are very strong network effects, lock-in effects. This is, I've heard that WhatsApp is very popular in Brazil as well. So a messaging platform is only useful when the people you are trying to talk to use the same messaging platform. And that is why it is very hard for a competitor of WhatsApp or Facebook to enter the market, since no one is on the platform yet. The large platforms have data-driven advantages. For example, Amazon Marketplace has the possibility to get a good overview of what people like and what people buy, and use this to their own advantage. Whereas smaller companies who might not have such a big customer base don't have these the same advantages. These facts all create high barriers for entry. So the idea of the DMA is now to regulate only a small number of the largest undertakings with considerable economic power to ensure the proper functioning of the internal market and make sure it remains contestable and fair. This is other than the DSA. The DSA applies to platforms in general. It has some specific higher obligations for very large online platforms. So the DMA only applies to the so-called gatekeepers. So I will give you a quick overview of our agenda today. I will start with some examples prior to the DMA and how gatekeepers have existed for a long time now, even though the term is new, at least in the context of a regulation. I will talk about the scope of the DMA. It applies to core platform services by so-called gatekeepers. I will give a quick overview of the obligations under the DMA, Article 5, 6, and 7, and some others I will get into as well, and also into the possibility of suspension and exemption from the DMA. In the end, I will talk a little bit about enforcement, the competent authority, market investigations, and which is most interesting to some people, fines, and then to close off the relationship to EU and national antitrust law, as the DMA also touches on antitrust law. So my first example is the first browser war, which took place at the end of the 90s. Back then, Netscape was one of the first publicly available web browsers and had a market share of about 80% in 1995. Then Windows was getting very popular on personal computers and pre-installed their Internet Explorer on every Windows machine, and therefore gained a market share of 90% within 6 years. This has been an issue in the courts of the United States, where a court case was pending against Microsoft, which was eventually settled, but won in first instance. And also in the EU in 2014, the European Commission fined Microsoft almost $500 million for not complying with the commitment to offer every user a choice of browsers. So you see, this is an ongoing issue. Another example would be Epic Games, Apple, and in-app purchases. Maybe you've heard about Epic Games and their popular app game Fortnite. So in order to get an app onto the iOS platform, iPhones, these apps have to be distributed through Apple's App Store. And for in-app purchases in apps distributed via the App Store, Apple would take a 15 to 30% cut. So 30% for upfront app purchases, and then 15% for ongoing plans. The issue was that the people offering apps on the Apple App Store were contractually obliged not to inform the users of cheaper prices on the web, since Epic Games didn't have to pay a cut to Apple when offering the app directly on, or the subscription directly on their website. They could, in theory, offer it cheaper, but they could not inform the users of the cheaper price. So in 2021, a United States court again found that this was a violation of the California unfair competition law to not allow app developers to mention payment systems available outside of the App Store. Another example would be in 2021. By the way, on my last slide, I will have some links for you. One of the links will also provide a link to the Portuguese text of the DMA for you to read, since Portugal is also a EU state. Everything will be available in Portuguese as well. So in 2021, Reuters ran a headline: Amazon copied products and rigged search results to promote its own brands, documents show. So Amazon is, as you know, running the Amazon marketplace, and it was alleged to have monitored which products fared well on the marketplace sold by by sellers. Amazon then was alleged to have copied said products and distributed it under their own Amazon Basics brand, and also set the search up in a way that it was presented before their competitors. So Amazon was basically leveraging its role as a marketplace operator and a marketplace competitor at the same time. A last example I've already given is that WhatsApp users can only communicate with other WhatsApp users over the WhatsApp app, of course. So this is where the EU steps in with the DMA. Before talking about the DMA, I want to give you a quick overview of the two main types of EU legislation. There are more, but directives and regulations are the basic ones. For directive, a rule must be transformed into national law. So it does not come into effect, at least in most cases, directly. And directives can aim at a full or a partial harmonization. A full harmonization means that member states are not allowed to introduce further rules beyond the rules in the directive, and partial harmonization means that even though member states have to adopt the rules laid down in the directive, they can go beyond. One question to the interpreter: do I have to speak slower, or is everything okay for you? Okay. 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 So other than the directive, a regulation is immediately applicable as a binding legislative act. So it does not have to be transformed into national law. Both directives and regulations contain of recitals and articles. The recitals give the reasons for the legislative act and can be used to interpret the articles. The articles themselves contain the law as you know it. So the DMA is a regulation, which means it is immediately applicable in every member state automatically. It applies to core platform services, which are operated by a gatekeeper. So what are core platform services? Core platform services are defined in the DMA, and they are very narrowly defined. So anything that is in this paragraph 2 is a core platform service, and something that is not in the paragraph 2 is not a core platform service. More platform services can be added in the future. So we're talking about online intermediation services like Amazon Marketplace, the Apple App Store, and the Google Play Store. Online search engines such as Google Search, Bing, or DuckDuckGo. So just to make clear, these are just examples, and not every single service put down here is also operated by a gatekeeper and therefore under the DMA. Online social networking services like Facebook or LinkedIn. Then video sharing platform services like YouTube, Vimeo. Number independent interpersonal communication services like WhatsApp or Signal. Operating systems like Windows, Mac, iOS, Android, Chrome. Web browsers such as Chrome, Edge, Firefox, Safari. And this means standalone web browsers as well as integrated web browsers like WebView on mobile operating systems. Then virtual assistants like Siri, the Google Assistant, or Gemini, and Alexa. Cloud computing services like AWS from Amazon and Azure from Microsoft. And online advertising services like Meta Ads or Google Ads. So we know what the core platform services are. Who is a gatekeeper under the DMA? This is put down in Article 1, Paragraph 1 and Article 3 DMA. It says an undertaking shall be designated a gatekeeper if it has significant impact on the internal market, it provides a core platform service, which is an important gateway for business and to reach end users, and it enjoys an entrenched and durable position. In paragraph 2 of Article 3, there is a presumption. It gives thresholds. When the thresholds are met, the person or the undertaking fulfilling the thresholds or meeting the thresholds is considered a gatekeeper. However, an undertaking can also be a gatekeeper if the threshold is not met. So one significant impact is defined as an annual turnover equal to or above 7.5 billion in each of the last 3 financial years, or an average market capitalization of at least 75 billion euros. And this is not just with regards to the potential core platform service, but to the entire undertaking. So everything a company operates would go into this number. And it has to have provided the core platform service in at least 3 member states. For the core platform service is an important gateway if it has at least 45 million monthly active users in the union and 10,000 yearly active business users. And the thresholds have to be met in each of the last 3 financial years. As I already said, it shall be presumed that an undertaking fulfills or shall be designated as a gatekeeper if these thresholds are met, but it is not mandatory. Once the criteria are met, the undertaking has to notify the Commission, Article 3, Paragraph 3, so the DMA is self-executing. Also, if a gatekeeper or potential gatekeeper fails to provide the information and notify, the Commission may set a deadline to do so, carry out interviews and conduct inspections. If the undertaking still fails to provide this information, the Commission may consider the undertaking a gatekeeper anyways based on the information it has. The undertaking may argue that it is not a gatekeeper even though it meets the thresholds. The Commission can review the status of the gatekeeper on its own initiative, so to see if the undertaking is still to be considered a gatekeeper under the DMA. And lastly, mergers where a gatekeeper is involved have to be indicated to the Commission. So who has been designated a gatekeeper? I have inserted this table I got from Wikipedia, which makes it clear that this is not something that a lot of undertakings have fulfilled, have met the thresholds. It is mainly the big ones: Alphabet, Amazon, Apple, ByteDance, Meta, and Microsoft. Alphabet for Google online advertising service, for Chrome, Google Maps, Google Play, Google Shopping, for operating system Android, for the search engine Google Search, and YouTube for video sharing. Amazon for Amazon advertising for its marketplace, Apple for Safari, the App Store, iOS and iPadOS, ByteDance for TikTok, Meta for Meta Ads, the marketplace, WhatsApp, the Facebook Messenger, Facebook and Instagram, and Microsoft for Windows and LinkedIn. And the DMA only applies to the core platform services which are named here. So Apple has to abide by the DMA for Safari, the App Store, iOS and iPadOS, but not for Mac OS or tvOS. So what are the obligations a gatekeeper has to meet? They are specified in Article 5 to 7 DMA. And gatekeepers have to ensure and demonstrate effective compliance with the obligations within 6 months of designation, according to Article 11 DMA. So there are 2 types of obligations in the DMA. One are the obligations in Article 5 DMA, which are laid down specifically, and then the obligations in Article 6 and 7, where the aim of the obligations is specified, but it's not specifically specified what the gatekeeper has to do in order to fulfill the obligation. So it's a best effort first, and the Commission can start proceedings pursuant to Article 20 and further specify obligations. A gatekeeper can also pre-submit intended measures to the Commission for review and ask for their opinion whether it is effective enough. So I will give a quick overview of the obligations. I will go through all of the obligations under Article 5, and I've picked some from Article 6. So the gatekeeper shall not process for the purpose of providing online advertising service personal data of end users using services of third parties that make use of core platform services of the gatekeeper. So this concerns the fact that many marketing and ad networks use plugins and cookies on the sites of third-party websites and track users not only on their own platform but also across the internet. And these obligations to not do the following things are only unless the end user has been presented with a choice. So if the end user has given consent, the gatekeeper can do the things in subsection A to D. The gatekeeper cannot combine personal data with personal data from any further core platform services. So, for example, Facebook should not combine data from their social network Facebook and WhatsApp. It should not cross-use personal data, and it should not sign in end users to other services of the gatekeeper in order to combine personal data. Further, the gatekeeper shall not prevent business users from offering the same product or services at prices or conditions that are different. So the gatekeeper cannot contractually obligate the business users to give a best price guarantee for the gatekeeper's core platform service, even though the gatekeeper might keep a certain cut of the proceedings. The gatekeeper also has to allow business users to tell the users about better conditions via the core platform services. So an app could display a message, purchase our service from our website at a 20% discount, for example. And it also has, of course, to allow the end user to conclude a contract with the end users. And of course, this all would not make any sense if the end user was not allowed to use the subscriptions or content acquired off the platform on the platform. So if you rent a movie from an online movie subscription service such as Amazon, you have to be able to play this movie on the app even though you have not bought it via the app. The gatekeeper cannot mandate the business users or end users from raising an issue of non-compliance with the relevant union or national law. The gatekeeper shall not require end users to use or businesses users to use services provided by the gatekeeper, such as identification service, web browser engine, or payment service. So the possibility to offer a service on a core platform service cannot hinge on the use of other services of the gatekeeper as well. Lastly, the gatekeeper has to provide each advertiser to which it supplies online advertising services price and fees paid, the remuneration received by the publisher of the ad, and the metrics on which each of these prices, fees, and remunerations are calculated to make the ad market a bit more transparent and prevent the gatekeepers from leveraging their market dominance. The same information has to be provided to the publishers of the advertisements as well. So these were the obligations under Article 5. I will continue with some of the obligations from Article 6. So firstly, the gatekeeper shall not use in competition with businesses any data generated or provided by those businesses in the context of their use of the relevant core platform services. This concerns the example given in the beginning about Amazon, where Amazon was alleged to have used the data generated on its platform, the sales data, to compete with the seller on the Amazon marketplace. So the next two ones are a big one. So the gatekeeper has to allow and technically enable end users to easily uninstall any software applications on the operating system of the gatekeeper that are not essential to the functioning of the operating system. And he has to allow and enable the users to easily change default settings on the operating system, assistant or web browser, and even prompt end users at the moment of the end user's first use to choose from a list of the main available service providers. This is something that has been done by large platform providers for a longer time, at least in Europe. Probably you've seen it as well when installing, for example, Android for the first time. It will ask you for to choose web browsers, and a similar thing with Microsoft Windows. Also, so this is also a bigger thing concerning mainly Apple right now. The gatekeeper shall allow and technically enable the installation and effective use of third-party software applications or software application stores. And it shall not prevent the service providers from prompting the end user to decide whether they want to set this other software application or software application store as their default. So third-party software applications are pretty much self-explanatory. These are apps you can download from somewhere else than from the App Store, as was usual with desktop operating systems for the longest time. In Windows and Mac OS, you could always download a software from the internet and install on your device. And software application stores are the applications that allow you to download applications from a single source. So this is on iOS, this is the Apple App Store, and on Android, the Play Store. However, on Android, you can already install different stores if you like. For example, the F-Droid store for open software. Samsung and Amazon also provide stores. However, the gatekeeper shall not be prevented from taking measures to ensure that third-party software applications do not endanger the integrity of the hardware or operating system if no less invasive method is available to them. Also, they are allowed to enable the end users to effectively protect security in relation to third-party software applications. So, for example, I can imagine a setting that allows or disallows the installation of third-party software as it exists in Android already today to fall under this article. Under Article 6, paragraph 9, the gatekeeper has to ensure the portability of data provided by the end user or generated through the activity of the end user in the context of using the relevant service, including real-time access to this data. One example would be portability of playlists you have created on one service to be portable to a different service. This aims to enable the user to change services more easily without losing work they have invested into the service. The next two things concern advertisers. The number 8 concerns advertisers. The gatekeeper has to provide to advertisers free of charge access to performance measuring tools of the gatekeeper, so they can carry out their own independent verification and can see how their marketing campaign fared, to not have to rely on the information given by the gatekeeper exclusively. And a big one is also the gatekeeper has to provide to any third party providing online search engines access to ranking, query, click, and view data, so they can train their own algorithms to set up a competing search engine. Because one of the problems with search engines is that you need this data, ranking, query, click, and view data, in order to improve the online search engine. But if you're not a big online search engine, this data is usually not available to you. In Article 7, the DMA obliges gatekeepers of number-independent interpersonal communication services like WhatsApp to provide the possibility of communicating with the service through other services. Instantly, the gatekeeper has to enable end-to-end messaging and file transfers, so images, voice messages, and videos. Within 2 years, the gatekeeper has to enable group chat, and within 4 years, voice and video calls between 2 individual users and in groups. This is something that links more to the GDPR. The gatekeeper has to submit an independently audited description of techniques for profiling of consumers to the Commission, and the Commission has to transmit that description to the European Data Protection Board for review. And the gatekeeper also has to make public an overview of the audited description. To ensure compliance To ensure compliance, the gatekeeper has to introduce a compliance function within their undertaking. It has to be, it will be tasked with organizing, monitoring, and supervising the measures, and informing and advising the management and employees of the gatekeeper on compliance. And of course, it has to be somewhat detached from the day-to-day business in order to be independent. Specific obligations can be suspended on the request by a gatekeeper on the claim that the specific obligation would endanger the gatekeepers beyond the gatekeeper's control, the economic viability of its operation in the union. And this suspension is to be reviewed every year if granted. The gatekeepers can be exempted in whole or in part on the grounds of public health or public security. And the gatekeeper cannot segment or subdivide or fragment the undertaking in order to circumvent the thresholds in Article 3 DMA. So the Commission can still designate an undertaking as gatekeeper, even though it has segmented. So to enforcement, the Commission is the sole authority competent for enforcing the DMA. However, national antitrust authorities can conduct investigations into non-compliance, but have to inform the Commission, who can decide whether to open proceedings. And once the Commission takes over investigations, the national antitrust authorities have to stop investigations in order to not do the investigation twice at the same time. The DMA can be privately enforced, where the DMA grants specific rights to individuals, and it can be enforced before the courts of the member states. And Article 42 DMA directs to the Directive on Representative Actions for the Protection of the Collective Interests of Consumers, which means that representative actions are possible if collective interests of consumers are concerned. The Commission can start market investigations on its own accord in order to designate gatekeepers, discern systematic non-compliance, and examine whether new services or platform services should be added as core platform services, or new practices should be regulated under the DMA. For this, the Commission has some privileges it can use, and it can use these privileges for any and all of its duties. So they can request information, carry out interviews, and conduct inspections. Now to the fines. Companies not following the obligations under the DMA can be fined up to 10% of the gatekeeper's worldwide turnover in the preceding financial year for violation of the core obligations in Article 5, 6, and 7, and specific measures specified by the Commission. The fines can go up to 20% of the gatekeeper's worldwide turnover for repeated violations. And again, this turnover is not the turnover with the core platform service, but the turnover of the undertaking as a whole. Then for more of secondary obligations, like failure to provide information or failure to comply with an obligation to notify the Commission, 1% of the gatekeeper's worldwide turnover can be set up as a fine. And the Commission also has the possibility to give penalties of up to 5%, periodic penalties of up to 5% of the gatekeeper's average daily worldwide turnover for non-compliance with orders until the orders are met. So if the orders are met eventually, the periodic penalties can be reduced after the fact. The term of limitation is 5 years from the day the infringement is committed, and the term of enforcement of decisions is also 5 years from the day the decision became valid. So in relation to EU antitrust law, the EU antitrust law is regulated in Article 101 and 102, and the DMA is without prejudice to EU antitrust law. However, the EU antitrust legislation is limited to certain instances of market power, and enforcement occurs ex post, so there are not, like in the DMA, specific obligations undertakings have to follow, but the antitrust authorities will look at things like concentration and monopolies. So this is more of a piecemeal approach, whereas the DMA is a concerted effort to allow the functioning of a market. So within the scope of the DMA, member states cannot impose further obligations on gatekeepers, but outside the scope of the DMA, member states are free to impose rules, but they have to be compatible with the DMA and may not result directly and solely from the status as gatekeeper. And if a national competent authority intends to enforce rules against gatekeepers which fall under Article 1, paragraph 6, it has to inform the Commission according to Article 38, paragraph 2. And to clarify, Article 1, paragraph 6 enlists areas where the DMA is without prejudice to, so national competition rules, prohibiting other forms of unilateral conduct, and merger control. So thank you for listening to me, and I will take questions now.
Thank you very much, Cornelius, for the very clarifying and comprehensive overview of the DMA. Thanks for the presentation. We can see big changes introduced by the DMA, right? It seems to be a real game changer in the industry. So thanks for clarifying the main aspects of the DMA. I have a few questions myself, but I think the public, the audience may also have questions. But one thing that I would like to ask you, I know that the DMA became applicable a few months ago, right? In March, I guess. And so have you already noticed any change in the European market for mobile apps, or including the user experience that is a consequence of the DMA, or any change in the practices of the gatekeeper like Apple and Google? Has anything modified?
Yes, so personally, I saw a change 2 days ago when I opened the Spotify app and wanted to renew my subscription. It asked me whether I wanted to use the in-app purchase payment scheme, or if I wanted to enter my own payment information and pay directly via the app. So that was one thing I noticed. The biggest thing right now in Europe is Apple opening the iOS ecosystem to third-party app stores. So up until now, the App Store was the only possibility on iOS to get an app onto an iPhone or the iPad. And since the DMA came into effect, Apple has, with very large restrictions, allowed third-party app stores to exist. They, however, still keep tabs on the apps which can be installed. They still check every app and sign it in order to run on the phones. And they also have very high thresholds for a third-party store to be able to exist. So I think they have to put down $1 million, and also pay a fee for every app installed via the App Store.
Thank you. I have another question, but I see that.
So it will be very interesting to see if that's actually in line with the DMA or if it's too narrow. But this we will see.
So thanks for clarifying, and for the people here in the audience, and I'm going to speak in Portuguese a little bit. Para o pessoal aqui na plateia, se vocês quiserem mandar perguntas, tem uma caixinha aqui de Q&A, tá? Podem já mandar, eu já vi que tem uma aqui. So there is one question here from Flavio, and he's asking about the enforcement of the DMA. So how do you see the enforcement so far? So if there is any investigation that has already been launched, any lawsuit you are aware, any complaint filed against gatekeepers for allegedly non-complying with the DMA, or it's too early to say that? Or on the other hand, do you know if any gatekeeper is filing lawsuits to challenge the DMA provisions before courts? How is the legal discussions?
So from my view, things are still very quiet. I'm not aware of any investigation yet on the DMA. I know that before the DMA came into effect, most of the undertakings now qualified as gatekeepers argued against being a gatekeeper, since of course they didn't want to face the regulation so much. I think since the gatekeepers have to report on the measures taken after 6 months, we will start seeing more in 5 to 6 months probably.
Great. So I have another question. So do you think that, I know that the DMA has the goal to modify the scenario of the industry. The current scenario is that we have an industry dominated by a few tech companies, and the DMA wants to create more opportunities to competitors or to small companies, to medium companies, to compete in this market. So do you think the DMA will succeed in achieving this goal? Do you think it's something possible? Because we see an industry very concentrated, right? Very concentrated. Do you think that the measures provided by the DMA will achieve the purpose of opening the market?
I think in some instances, yes. It's too early to tell. Things like search engines providing data to enable other companies to come up with competing services. This is something I can imagine that will have an impact, since a search engine is a low barrier service to try out. Something else like WhatsApp, for example, I'm not so sure if people are really going to use a third-party service, and also if they are using third-party services right now, it's not said that these will ensure interoperation with WhatsApp from their side. So I've heard that Signal has said that due to privacy concerns, they are not planning to open up their service to be interoperable with WhatsApp. I think where the impact will be biggest or big is the apps which can be installed on mobile operating systems, third-party apps. So in the past, with Windows and Mac OS, everyone was used to getting the apps and programs they wanted from the sources they wanted. And these very closed down ecosystems have been introduced with the mobile operating systems. And the companies operating the operating systems and the app stores have a very big leverage what to put on the app store. So for Android, it's been possible a long time to install apps from third parties. I think this is going to change the iOS ecosystem too.
Okay, thank you. And there's another question from the audience, and I was also gonna ask a question about this. It is about the conflict between the DMA purpose to open the market and the possible security risks. We know that Apple, specifically Apple, has been very vocal saying that by allowing more apps and more app stores, the DMA may create security risks to users. Yes. I know you said that there is a provision in the DMA by which the gatekeepers shall pay attention to security, but Apple says that it limits the ability to ensure security. So how do you see this kind of criticism?
So I think possibility and security are always on a sliding scale. You cannot have perfect security and have open platforms at the same time. For the specific implementation of Apple, I can say that since they are still examining every app they are assigning to be distributed via third-party app stores, with this specific implementation, I don't really see the difference to the Apple App Store. And also, I'm pretty sure there are going to be settings to allow or disallow the installation of third-party software. So as it exists in Android, so every user will be able to decide whether they want to install a third-party app or not. On the more technical side, I think it is the OS's job to segregate and isolate apps from one another. So the argument that apps will have more access to personal information this way can be countered with the argument that the app only has the access to information the operating system grants the app, and the user grants the app via the operating system. So I think while the argument that security cannot be ensured as well is probably correct, I also see the importance of users being able to decide what they want to run on their devices.
Great, and I agree with you. I think that we're going to see the results in the next years because of course it's very early to say. But another question, we saw in the presentation that the DMA relies a lot on user consent, like other legislations, like privacy legislations, and also the DMA gives more options to users. One key aspect is that users need to be informed about risks, about the terms and conditions. However, we know that users tend not to be very careful when reading terms and conditions. right? It's like human behavior. People just don't read the terms and conditions. So how do you think that users can be really empowered to understand risks and avoid installing malicious apps or apps with malwares from third-party app stores, for instance, if they don't read terms and conditions? That's a big challenge, I see.
I think it is, and we've seen the same thing with the GDPR, which for every use of personal data, you have to have a reason or a legal ground, and one of them is also consent. And we've seen that consent is given very freely by the users, and often not in an informed way, but more in a way, okay, don't bug me. So this is a problem, and this is maybe going to be a problem with the DMA as well, at least in certain aspects. We saw in Article 5, paragraph 2, the agglomeration of personal information from different services, which is only allowed with the consent. And also, as you have said, with the installation of third-party applications. But I think in the end, it comes down to digital literacy. You have to, as a consumer, you have to inform yourself or be informed by others of the risks and how to mitigate the risks and how to use your device. I mean, it's been common knowledge in the past. Use an antivirus software. Don't visit sketchy websites. Don't click on links in emails. Don't install anything that asks to be installed. 15 years ago, toolbars were a big thing. So I think it's, as always in life, you have to get accommodated to new risks. And
yeah,
yes.
That's a big problem now in Brazil, because there's a lot of scams, a lot. Every day people receive malicious links through messaging apps, and all kinds of frauds and scams, and people fall into that. It's very common, but I agree with you that that's something we need to learn as a society, right? The digital literacy is very important, and I agree. And another question is about the accountability mechanisms in the DMA. So in case of a security breach by a malicious app from an alternative app store, will the gatekeeper be held accountable? And how will be the accountability split? The developer of the app will be held accountable for damages caused to the user?
Well, the DMA does not address this, but I would assume it's the same as with a Windows program you install now. I think the operator will probably be liable if they have been negligent in any way. But ultimately, if you decide to install a sketchy app, it will probably be on you.
Yeah. So Brazil is very different because here we have a very strong consumer protection tendency. So I see that in Brazil, this would be very brought to court as litigation, and with users filing lawsuits against the gatekeepers or against the developers, saying that, oh, I am a consumer, so I don't have the information, I am vulnerable. And I see the Brazilian judiciary deciding in favor of consumers because of our tradition here.
Well, we have a similar thing with online banking, for example. So the bank will be liable for online banking occurrences or thefts when the user has not been negligent. So when a bank account has been compromised because of the technical setup, of course the account, the person whose account it is has to be reimbursed by the bank. But then again, if the bank shows that you've not been careful with your authentication or credentials, then it was your mistake.
Yeah, I see. We also have the problems here with online banking in Brazil. I think it's a world problem, right? Yeah. So I'm going to ask to the audience in Portuguese. Pessoal na plateia, se vocês têm alguma outra pergunta, alguma outra questão para trazer para o debate, para a provocação, eu posso passar aqui para o Cornelius. Senão eu vou, a gente já passou aqui do meio-dia, né? Aí eu vou encerrar aqui o evento, caso não tenham outras perguntas. So Cornelius, I guess this is all the questions, and thanks again. I guess that we are all now more aware of the DMA. We can understand the scenario, the big picture, the main aspects of the DMA, and it's going to be exciting to keep up with the developments in the European Union, and I hope we can see good results from the implementation of the DMA, and I hope that this legislation may inspire other legislations across the world, including in Brazil. I guess this will happen. So thanks again, and I hope we keep in touch. And
thank you for having me.
And if you want to say any final remarks, please feel free.
Well, thank you for having me. Have a nice conference. And I wish you good luck with the Brazilian DMA.
Thank you very much. It was a pleasure. Obrigado a todos, a todas. A Comissão de Estudos em Direito Internacional da Propriedade Intelectual da ABPI agradece pela realização desse evento. Muito obrigado, foi um prazer aqui passar essa manhã com vocês. Cornelius, thank you very much. Thank you. Bye-bye.
Bye.
As praias de águas cristalinas e piscinas naturais formadas entre os recifes fazem de Porto de Galinhas um dos mais belos destinos do Nordeste brasileiro. Este cenário paradisíaco vai receber em agosto o maior evento de propriedade intelectual e direito digital da América Latina. Porto de Galinhas será a sede do 44º Congresso Internacional da ABPI, tanto pela infraestrutura e beleza, quanto pela sua proximidade com a capital de Pernambuco. Está a 30 minutos de Recife e do Aeroporto Internacional dos Guararapes. Terra de um povo alegre e hospitaleiro, onde passado e futuro se encontram no misto de história, cultura e inovação, Recife tem a 4ª maior região metropolitana do país e é um hub para o desenvolvimento econômico de outros estados do Nordeste. Além disso, abriga o Porto Digital, um dos mais importantes polos tecnológicos do mundo, onde estão mais de 350 empresas e 20 mil profissionais trabalhando com inovação e tecnologia de ponta. Um cenário que coloca a capital pernambucana entre as 6 cidades líderes mundiais da indústria de TI, segundo o portal internacional Rest of World. E é de olho em todo este potencial que, pela primeira vez, a ABPI decidiu levar o evento para a região. Nos dias 12 e 13 de agosto de 2024, os maiores especialistas e profissionais de IPI do mundo todo estarão em Porto de Galinhas para debater os principais temas de propriedade intelectual e direito digital. E também, é claro, para muito networking.
Não perca a chance de fazer parte desse evento. Junte-se a nós no 44º Congresso Internacional da Propriedade Intelectual da ABPI. Estamos ansiosos para te receber lá.